This is one of those real property hypotheticals that gives the subject such a bad reputation. This is an enormously complicated, difficult problem involving an easement and mortgages. Take a look at the call of the question. What rights, if any, does Donald have regarding the easement? Discuss. We know that somebody who claims an easement can have a couple of different theories. First, an express easement, and possibly a prescriptive easement or some easement by necessity. They're pretty straightforward theories. We'll examine the facts. Question 2. What rights, if any, does Eve have against Pat and against Clara? Discuss. Here we've got two lawsuits. We know that a civil plaintiff is going to have one or more theories of liability and one or more prayers for relief, and we'll consider those issues with regard to both of the lawsuits mentioned in the second call of the question. Call of the question number 3, what rights, if any, does Pat have against Clara? Discuss. One more lawsuit, so we'll consider the theory of liability, the prayer for relief, and we'll reach some sort of a conclusion. In looking at the call of the question, we can tell that we're dealing with a racehorse question. We've got several lawsuits to consider, and just sketching out the basics is fairly time-consuming and elaborate. As it turns out, the first call of the question also requires us to consider more than one civil lawsuit. So let's go to the top of the question and see just how intricate and complicated these facts really are. In paragraph 1, we've got a very straightforward situation. Albert mortgages Blue Acre to Clara, and Clara records. So far, so good. A pretty straightforward first paragraph. Now, look at paragraph 2. Here, Albert grants an easement to Donald, and Donald doesn't record. But it's an express easement, and it is supported by consideration. Donald paid for this easement, Albert granted it to him, and like so many people with easements on the bar exam, Donald fails to record. Now, we can tell right up front that with regard to the first call of the question, Donald's principal theory with regard to this easement is that he has a valid express easement. And we also see that when it comes down to actually using the easement, Donald only uses 20 feet, not the full express grant. And that distinction is a very common little twist of the facts that you're going to see more than once. Even in your practice with me, you'll probably see it more than once. But as you do systematic practice on the multi-state and with regard to the essays, you'll see this issue comes up really over and over again. And it implies that our man Donald here might have a prescriptive easement theory, right? Because he's using less than the express grant. But as we consider the time frame presented by this question, all of the facts unfold in just a few years. So Donald is not going to be able to establish an easement by prescription because he hasn't occupied it long enough. Next, take a look at paragraph 3. Here, Albert mortgages Blue Acre a second time, this time to Eve, and Eve also records. So the mortgagees are doing a pretty good job of recording, and Donald has failed to record. Now, take a look at the very predictable facts that arise in the next paragraph. Albert defaults to Clara, so he has breached the mortgage he's failed to pay. And Clara forecloses on the mortgage, but Clara acts in bad faith also, because Clara fails to give notice to Donald or to Eve. And now we understand why Clara is a defendant in so many of these lawsuits. Finally, at the very end of the fact pattern, Clara sells Blue Acre to Pat for $80,000. So let's just pause for a moment and consider Clara. She has more than doubled her money very quickly, and she has done it at the expense of the various people that are suing her in the call of the question. So as we survey the characters in this question, Claire is the bad guy. She's the one who has acted unreasonably here, and although Albert has defaulted on a mortgage, beyond that, his liability does not appear to be very extensive. But not so fast. Let's take a look again and review the call of the question and review what a good answer to this question would look like. Call of the question number 1 is asking about Donald and the easement. Basically, he's going to be making an argument for an express easement supported by consideration. He doesn't have enough time to establish a prescriptive easement, but consider this. Donald also will have to assert rights against Clara and against Pat. So now we see that this fact pattern is really asking us to discuss 5 lawsuits, and to discuss 5 lawsuits even in the most generous amount of time for a bar exam essay, an hour, is very tricky business. And we can certainly see many multi-state questions which are based on a stem of facts very similar to this one. So turn the page with me for a moment. Let's take a look at the outline of issues that are presented, and let's consider how we would really answer the question. This gives us an opportunity both to focus on organizing and outlining what an essay might look like, but it also allows us to consider in a little bit more detail what the different rights and duties of these various parties are. So first we consider Donald. Donald is claiming an express easement based on an underlying contract. He paid consideration, he got a deed. The problem for Donald is that he failed to record that deed. Had he recorded, everything would be fine and his interests would be entirely secure. But he failed to record. So now we focus on the 2 defendants that Donald will have to pursue in order to obtain any kind of relief. And those defendants would be Clara and Pat. So first we focus on Clara. Clara recorded the mortgage that she had on Blue Acre even before Donald bought his easement. So Clara is the senior lien holder in this problem. But the problem for Clara is that when she foreclosed on Blue Acre, she didn't give Donald notice. All right, so what is the consequence of that? Who wins? If we are located in a pure race jurisdiction, there is a reasonable chance that Clara would win because she recorded first, and that's basically the end of the story in a pure race jurisdiction. But in a notice or a race notice jurisdiction, Donald would likely win because he is physically present, and anybody that inspected the property would have to come up with at least some concern about who is using this road. So the result is, in a majority of jurisdictions, Donald will prevail against Clara. What about Donald versus Pat? Pat, as the buyer of Blue Acre from Clara, doesn't obtain any more interest in the property than the seller had. So if we find that Clara had the property subject to the easement, then Pat is going to buy the property subject to the easement as well. So probably, unless, once again, we're in a pure race jurisdiction, Pat is going to be subject to the easement as well. So my final conclusion with regard to the first call of the question is, in a majority of jurisdictions, Donald does have a right to the easement. He'll be able to assert that right against Clara and against Pat. And to put the finest possible point on the analysis, Donald's rights are likely to extend only so far as the extent to which he has used the easement. So the full express easement probably will evaporate into thin air, and Donald will be entitled to use the easement to the extent that he already is using it. So now we turn to Eve's rights. Let's remember who Eve is. She is the junior mortgage holder. She's got actions against Clara and against Pat. What is Eve's problem with Clara? Clara foreclosed on Albert without giving Eve notice, and Clara had an obligation to give Eve notice. So the result is Eve wins as to Clara. Now how about Eve versus Pat? Again, Pat doesn't obtain any greater interest in the land than Clara had to give her. But we acknowledge that Pat does have one potentially winning argument, that she is a BFP. And if Pat does successfully establish that she's a BFP, cutting off Eve's rights as to Pat, then there would still be the possibility of indemnification. from Clara. So Eve is going to end up being protected one way or another. Her claims against Clara are stronger than her claims against Pat because it's Clara who actually was the wrongdoer. So now let's turn to Pat, who also is suing Clara. And remember, let's identify who these parties are. Pat bought Blue Acre from Clara, and Pat's problem that she is suing Clara over is breaches of the warranty deed. And here we see how these warranties, the seller's warranties in a real estate transaction, actually play out. Notice you've got to come up with them to discuss them. So the reason to memorize some of these checklists is so that we can call them up to discuss them on an essay. But notice, this little memorized laundry list ultimately is a fairly small part of this answer. The people who are able to carefully explain the relationship between these parties and go through the theories of liability and the remedies under time constraints are the ones who succeed. So if an applicant tends to space out one or two of the warranties, if that applicant is still clearly able to express and explain the relationships between the parties, forgetting one or two buzzwords is not such a big deal. But notice that Pat the buyer from Clara, bought a warranty deed. And so Clara, as the seller, made certain warranties about her interests in the property. She covenanted that she had season. She made an affirmative covenant against encumbrances. And the bottom line is Pat wins. Clara is on the hook, and that means that Clara is going to have to indemnify Pat against Eve's mortgage. And the result likely will be that Clara pays. But Clara can afford it. Again, focus on the facts. And notice that Clara more than doubled her money. She can pay everybody off and still make a fairly tidy profit based on her foreclosure. So as we step back and review this question together, we see that the principal task is to monitor and explain the relationship between the parties. That requires a rigorous approach to organization. Then, if you don't have that organizational approach, it's very difficult to show your knowledge. On the other hand, if you understand how to organize the issues here, you can cover up any minor gaps in your legal knowledge by explaining how the relationships play out and which are the liable parties and the extent to which their liabilities really are present.